The lecture on administrative law. This is the fact of the case of J R Raghupathy. So, an act was brought by the Andhra Pradesh government for the object of bringing the administration closer to the people. And this act was the Andhra Pradesh District Act of 1974. Now, they further amended the act in 1984. But the issue is involving two parts of the law for which there was no statutory provision available as to the selection of or creation of revenue models and to the selection of what will be the revenue headquarter in such districts. So there was an authority which was mentioned in the law, and this authority will be deciding what will be the revenue mandals, what will be the mandal headquarters. Now, thus, the revenue mandal, the process of electing the revenue mandal was mentioned in a white paper which was issued by the government. The process of selection of headquarters was mentioned in the appendix 2 of the white paper which was issued by the government. What happened that the authority decided that A is a place which will be the revenue headquarters in the area. The matter went to the High Court. The High Court quashed the decisions of the authority and then held that there was an abuse of discretion, and the High Court then selected B as the headquarters. Therefore, the state is going against such a decision of the High Court, and two issues which are mainly framed is what is the extent of power of judicial review available to the courts, and can non-statutory rules be enforced by the courts. As I told you that for the designations of revenue mandals and headquarters there was no statutory provision. Only a white paper was issued in which the procedure of selection was mentioned. So, can the court enforce non statutory rules? Is one of the issues framed under this case. And in the very first case, that is the Padfield's case. Now, it is stated that the decision of the Padfield case is an important landmark in the current era of judicial activism in this area of administrative law. So, the fact was that the minister in this case had the power to appoint a committee. Now, he was given this power under a statute, but there was a discretion that if he thinks fit, he would constitute a committee. The minister refused to constitute a committee. The reason which was stated by the minister was that it would be politically embarrassing for him. So, this was the reason that he would be embarrassed politically in the parliament if he did not go with the recommendations of the committee. So, this reason was held to be irrelevant, and then it was held that he had acted ultra vires by taking into account factors that were legally irrelevant and by using his power in a way to calculate and to frustrate the policy of the act. It is important to note down the judgment of Lord Reed in this case. He said that the parliament must have conferred this discretion, but this discretion has been conferred with the intention that the authority should use this discretion to promote the policies and objects of the act. So, if by the exercise of discretion there is an abuse of the act, then such is not the intention of the parliament. Further, Lord Denning in Breen versus Amalgamated Engineering Union, he said that the discretion of a statutory body is never unfettered. It is a discretion which is to be exercised according to law. That means at least The statutory body must be guided by relevant considerations and not by irrelevant considerations. If its decision is influenced by extraneous considerations, which it ought not to have taken into account, then the decisions cannot stand. Again, I repeat, which I mentioned in the very first lecture about this abuse of discretion. No matter that the statutory body may have acted in good faith, nevertheless, the decision will be set aside. This is established by Padfield, which is a landmark in modern administrative law. So, after Padfield, in Laker Airways case, the matter was again with the power of the minister who could override certain statutes relating to civil aviation in the times of war or in the interest of national security or in the interest of international relations or for the protection of environment. So the minister was having an overriding power against the statutes. So in this case, Lord Denning held that the review of the prerogative is assimilated to that of statutory power. So if the statutes can be reviewed, the powers under a statute can be reviewed, Lord Denning thought that the prerogative powers can also be reviewed. He is holding this statement on the ground that, seeing that the prerogative is a discretionary power to be exercised for the public good, it follows that its exercise can be examined by the courts just as any other discretionary power which is vested in the executive. So, if a statute provides for discretionary powers to the executive and the prerogative powers are given to the ministers, then prerogative powers were as much capable of abuse as any other power and therefore subject to judicial review. He said that likewise it seems to me that when discretionary powers are entrusted to the executive by the prerogative, in pursuance of the treaty making power, the courts can examine the exercise of them so as to see that they are not used improperly or mistakenly. So, what is the crux of the judgment is that he equated statutory powers with the prerogative powers. He equated the rules relating to statutes of judicial review to the prerogative exercise of the powers. The extension of the rules of Padfield and Laker Airways will be found in the CCSU case, which is also known as the GCHQ case. Now, I would request you to pay attention to this paragraph. It says, in CCSU's case, the House of Lords reiterated broader standards of review of the exercise of prerogative powers. Remember, these are the grounds of judicial review for the prerogative powers. It was said in the judgment that powers exercised directly under the prerogative are not by virtue of their prerogative source automatically immune from judicial review. So there is no immunity of prerogative powers in absolute. If the subject matter of a prerogative power is justiciable, then the exercise of the power is open to judicial review. So the ground of review of prerogative powers is told to be the justiciability of the subject matter. Now I told you in the earlier lecture that you have to remember Lord Roskill by the word kill. Now he added certain exemptions or exceptions to the rule of judicial review for the prerogative powers. For those actions relating to the making of treaties, the defense of the realm, the prerogative of mercy, the grant of honors, and the dissolution of parliament and the appointment of ministers are not justiciable or reviewable. So the Lord Roskill is adding certain exceptions. But later on, you will find that Lord Roskill has given such explanations to the power of judicial review that these exceptions itself will not hold water. Now, the second point, administrative action is subject to control by judicial review under three heads, which I have already told you: illegality, irrationality, and procedural impropriety. So there is a quotation by Lord Diplock, which I think is important for you to remember. It says that judicial review has, I think, developed to a stage today when, without reiterating any analysis of steps by which the development has come about, one can conveniently classify under three heads the grounds on which administrative actions are subject to control by judicial review. The first ground I would call illegality, the second is irrationality, and the third is impropriety. Further, Lord Roskill, now remember the exceptions and the ground he is using for judicial review of prerogative powers. He says, to talk of the act as an act of the sovereign savors of the archaism of the past centuries. So he is against the archaism of the past centuries. Further, one more statement which is very important. He says to speak of the acts of sovereign as irresistible and absolute is actually the clanking of medieval chains of the ghosts of past. So they are adding certain inroads into the exercise of prerogative powers by the action of judicial review by the courts. But still, Roskill is adding certain exceptions which you need to remember. The effect of the decisions of Padfield, Laker, and GCHQ case is summed up in this paragraph. Now, this paragraph is taken from Graham Alder's and John Alder's book, Application of Judicial Review, Law and Practice. It is stated that there is a general presumption against ousting the jurisdiction of the courts, so that statutory provisions which purport to exclude judicial review are construed restrictively. There are, however, certain areas of governmental activity, national security being the paradigm, which the courts regard themselves as incompetent to investigate. So it is said that the issues where national security is involved, the court is incompetent to investigate beyond an initial decision as to whether the government's claim is bona fide. So there is only one ground of review in matters of national security which is incompetent of investigation by the courts is that the claim of the state is bona fide or a mala fide. In this kind of non justiciable area, judicial review is not entirely excluded but very limited. It has also been said that powers conferred by the royal prerogatives are inherently unreviewable. But since the speeches of House of Lords in GCHQ case, this is now doubtful. So, what it means to say that even the non justiciable areas can now be reviewed with certain exceptions. And remember Judge Roskill. Lord Diplock Roskill appeared to agree that there is no general distinction between powers based upon whether their source is statutory or prerogative, but that judicial review can be limited by the subject matter of a particular power, and in that case, national security. But there are certain exceptions which are mentioned here. Many prerogative powers are in fact concerned with sensitive, non justiciable areas, for example, foreign affairs. But some are reviewable in principle. What are those? So the prerogative powers which relates to civil services where national security issues are not involved. Another example is the prerogative of the Attorney General whether to decide whether to institute a legal proceedings against a person in public interest or not. So these are certain areas which are non-justiciable but under the power of judicial review by the courts. So one of the important statements that the decision of House of Lords in Padfield case marks the emergence of the interventionist judicial attitude. Prerogative power is reviewable or not depends on whether its subject matter is justiciable or not, that is suitable for judicial control or not. One statement from H.R. Wade of Administrative Law: it is from this presumption that the courts take their warrant to impose legal bounds on even the most extensive discretion. So, what is this presumption? It is said that the Parliament confers powers for the authorities to act in a prudent manner. And this is the presumption when they are making the legislation. On the other hand, Parliament cannot be supposed to have intended that the power should be open to serious abuse. It must have been assumed that the designated authority would act properly and reasonably. So the court has to move ahead with the presumption, with the assumption that the authority would act properly and responsibly. If that is not done, then there is a abuse of the exercise of judicial review. So it is from this presumption that the courts should take their warrant to impose legal bounds. This presumption that the authorities have acted properly and responsibly. Now I would take you to the decisions of the case. It said, I have told you that the creation of revenue mandals and the selection of revenue headquarters were based on the white paper issued by the government. So the court now is saying is that they were nothing more than administrative instructions not having any statutory force, which did not give rise to any legal right in the favor of writ petitioners. I have one objection to this result of the judgment. Why? Now we are distinguishing between statutory powers and non statutory powers. So I would take you to one of the decisions, which is R versus Criminal Inquiries Compensation Board case. Now the matter here was that there was a compensation to be given to the victims of crime. So whether the payments are subject to judicial review or not was the issue. The court was asked to refer to the case of Ridge versus Baldwin, that only those decisions can be taken under judicial review where the discretion exercised were affecting rights. If there was no right which was affected, then there would be no judicial review. Now, payments made under the scheme was paid in ex gratia and was not a matter of any legal right. So the argument was that the board was not subject to jurisdiction of the courts since it did not have what was described as legal authority in the sense of statutory authority, because the payment was based on the grounds of ex gratia. So the judgment of Lord Parker is important. Now says that true that the boards are not set up by the statute, but the fact they are set up by the executive government, that is under the prerogative, does not render their acts any less lawful. Indeed, writ of certiorari has been issued not only to courts set up by the statute but to courts whose authority was derived from the prerogative. Once the jurisdiction is extended to tribunals as opposed to court, there is no reason why the remedy by way of certiorari cannot be invoked to a body of persons set up under the prerogative. Further, See Lord Diplock. So it is from the ex parte Lyons case that it therefore follows that a non statutory inferior authority like the board, constituted under the prerogative powers, is just as well amenable to the jurisdiction of the court as a statutory body. So, a non statutory body is equated as a statutory body. But the court in this case stuck to the argument that the white paper issued was only administrative instructions and not having any statutory force. Even those non statutory bodies have been said to be within the scope of judicial review.